Good morning, friends. I feel you might be in the best of your spirit. So, I am going through one of the important case law which was decided by our Honorable Supreme Court of India on, on 9th January 2025. This is latest judgment. In this case, Honorable Supreme Court, while acquitting an accused of cruelty and abetment of suicide, observed that to apply section 113B that talks about presumption as to dowry death of the Indian Evidence Act, clear evidence for incessant harassment is essential. The court stressed that in the absence of such evidence, it cannot straightaway invoke the provisions of this act. Before going further, I may talk about concerned portion of section 113B, which say that presumption as to dowry death. When the question is whether a person has committed the dowry death of a woman, and it is shown that soon after her death, such woman had been subjected to by such person to cruelty or harassment, far or in connection with any demand for dowry, the court shall, the word is shall presume that such person has caused the dowry death. So essentially, the present appellant was the brother-in-law of the deceased. It was the prosecution case that there was harassment at the end of husband, in-laws, and the appellant. Redundantly, the deceased doused herself with kerosene and set herself on fire. Consequently, the trial court convicted him under Section 306, that is, abetment of suicide, and Section 498, capital A, that is, husband or relative of husband of a woman, subjecting her to cruelty of the Indian Penal Code. And under the Dowry Prohibition Act. This order was affirmed by the High Court. That's why he has came before the Honorable Supreme Court under appeal. This case was heard by a bench of Justice J.B. Pardiwala and R. Mahadevan. And they pointed out that there is practically no evidence against the appellant for abetting the suicide. The court also drew a distinction between section 113 capital A, that is presumption as to abetment of suicide by a married woman, and section 113 capital B of the Evidence Act. Under section 113B, the court may presume, unlike under section 113A, where the statute says that the court shall presume. So this is a vital difference between the two provisions, which raises a presumption as regards abetment of suicide. When the courts below wants to apply section 113B of the Evidence Act, the condition precedent is that there has to be first some cogent evidence as regards incessant harassment. In the absence of any cogent evidence as regards harassment or abetment in any form, like aiding or instigating, the court cannot straightway invoke Article Section 113B and presume that accused abetted the commission of suicide. So, based on the observation, the court set aside the impugned orders, and allowed the present appeal. As far as the appellant, he was represented by Advocate on Court Mr. Bhartabhushan, and the respondents were Senior Advocate Mr. K. Parmeshwar, Advocate on Court Mr. Surya Sahi, and the case name is Rampyari versus State of Uttar Pradesh, Criminal Appeal Number 1408 of 2015. You can also go to the citation for more details, that is 2025 Live Law SC 66. This is all about short video on this topic. Enjoy yourself. Have a nice day. See you again. God bless you all.